It is a state law that we have talked about for years. Arkansas Act 372 would punish libraries if they check out anything with obscene or sexually explicit material to minors. It's faced many legal hurdles, but a recent ruling paves the way for the law to officially go into effect. Libraries have told us why they're worried about the aftermath, and a new report from the Arkansas Advocate echoes those concerns. I sat down with advocate reporter Tess Vrbin to hear why many librarians are saying they have some unanswered questions. All right, let's start with an overview of what Act 372 is. Tell us what it is and why state lawmakers passed it.
Okay, so Act 372 passed the legislature and was signed by Governor Sanders in 2023. It creates criminal liability for librarians furnishing a harmful item to a minor. That's a direct quote out of the law. It doesn't really define the term furnishing or harmful to minors. It also gives local government officials, so city or county governments, the final say over whether a book is available on library shelves if someone who doesn't want that book available or wants it moved in the library is dissatisfied with the outcome of submitting a challenge form to the local library, because it's standard for libraries to have challenge forms if somebody questions why a book is available at all or on the shelf. And when libraries address that, this law would give people the ability to go past the library to local officials saying, I don't like how the library handled this. So those two sections of this law were challenged in court. People were very frustrated about it. This law also applies to school libraries and gives school boards some authority over library content, but just the parts of the law that applied to public libraries got challenged in court.
Yeah, we're going to talk about those challenges here in just a second, but give us an idea as to what punishments there are in this law that if a librarian violates, what do they face?
If a librarian is found in violation of Act 372, they could be charged with a Class A misdemeanor, which has a maximum punishment of up to 1 year in prison. And like you mentioned earlier, why did the legislature pass this? Well, there's been some buzz and some frustration over the past few years in the legislature from some local governments in Arkansas, or just from some members of the population, folks who believe that kids shouldn't have access to books with what they consider controversial topics. Some say that it's inappropriate for kids to engage with content about the LGBTQ community. Some say that kids shouldn't have access to books about sex education, some of which also involves the LGBTQ community. Some have said that kids shouldn't have books that address systemic racism. Those tend to be the things that come up over and over again as far as what some consider inappropriate.
So you mentioned the legal challenges: Fayetteville Public Library, Eureka Springs Library, 16 other ones actually have moved now to sue the state after all this. And you also briefly mentioned the legal history in the case leading up to last month's ruling. Talk about that for a second.
Like you said, there are 18 plaintiffs in this case. Some of them are libraries or library directors. Some are booksellers. There's a bookstore in Little Rock and one in Fayetteville that are among the plaintiffs. Some are First Amendment advocacy groups, and some are just library patrons from different parts of the state. They sued about 3 years ago in federal court, and a federal judge up in Fayetteville at first temporarily blocked the law. And then later in 2024 issued a permanent injunction saying this is against the First Amendment because it could lead to content-based restrictions that violate the First Amendment freedom of speech. So the state appealed in 2025. Then in June of this year, about 2 months ago, the appeals court up in St. Louis heard the arguments from both sides. And at the very end of July, the appeals court ruled that they got rid of the injunction. They said that it can go into effect. They haven't yet issued the mandate saying that libraries must comply, but we expect that to come out at some point soon. The plaintiffs may or may not take more action, that has yet to be seen.
I was going to say it should be any day now when we get that mandate. So now that the law is
Mhm.
allowed to go through, we did a story with the Fayetteville Public Library. They told us it is going to be a huge task for librarians to go through every piece of material. What have been the early things that you have heard that libraries are doing now to comply with all this?
Well, one library in particular is taking preemptive action. The Independence County Library in Batesville announced the day after the court ruling in July that for now, it would no longer allow library users under 18 to check out graphic novels aimed at adults or manga content, which, for those who don't know, that's a style of comic books and graphic novels from Japan. I talked to the director of the Independence County Library, Carlene Morrison. She said that some of these books have sexually explicit imagery. Not all of them do. So, library staff have been combing through the materials under this blanket restriction to try to find the ones that do not have sexually explicit images and remove them from the restricted list and allow kids to check them out without parental permission. Kids can still access those books if they do have parental permission, the ones that are restricted, but Morrison said that those books are being treated like R-rated movies, basically. She also said that library staff is working on putting stickers on books with sexually explicit prose. They focused on images first, but they are also considering prose, like 50 Shades of Grey, probably the most famous example, as something that they consider worth warning parents about and saying that minors could only access those books with parental permission. So those are steps that they are taking while the court still hasn't issued the mandate.
All right, so I know some of your reporting and visiting with some of these directors that they still have a lot of unanswered questions. Talk about what you know about their biggest concerns.
Right. I've spoken to a few other library directors. They're concerned about what they call the vagueness of the language of Act 372. And that was actually part of the grounds on which the federal judge that blocked it issued the injunction saying this language is too vague. It doesn't define the term make available. So librarians are uncertain if that just means having a book on the shelf and in the catalog, not necessarily putting a book on display or telling a kid that it's there. So if just having a book at all will put them at risk of prosecution, some libraries are really small, and in rural areas, they might just be one room. So how do you keep a child out of the vicinity of a book that maybe they're not old enough for and even let them in the library at all? That's a big unanswered question that the ruling didn't address. I spoke to one of the plaintiffs, Central Arkansas Library System Director Nate Coulter. He is also an attorney. He said that one thing that he's concerned about in the big library system, 14 branches that he oversees, if just having certain books on the shelves is enough to trigger Act 372, then how is this library system going to carry out these civics classes that they hold for high school students? Because those are held at libraries, and if the kids are in the vicinity of the books that might be considered inappropriate, would that trigger the law? Can they still have their civics classes? And these classes help high school students get required community service hours that they need to graduate. That is part of state law. So that is a bit of a conundrum. And some
Yes.
library directors, including Coulter, also said that little free libraries, which are those little boxes of books that sometimes you see on the street. They look like they're in big mailboxes. Libraries set those up and then just kind of leave people to their own devices with it. The general population can take and leave books there. But since the libraries created that venue, if there is a book in there that some consider inappropriate for minors, would the library get in trouble for that, even though they mostly leave that alone? That's another thing that is not addressed.
My goodness, sounds like there's still a lot to be decided. So I know you
Mhm.
and we have done stories a number of them with the Crawford County library system and how it played a big role in all of this. Talk about what they did before this law went into effect.
Right. So the law went into effect in the middle of 2023. Earlier that year, Crawford County's 5 library branches placed children's books with LGBTQ themes or characters in social sections. That's what they called them. After conservative members of the community went to the quorum court and complained about those books, saying they don't want kids to access them. So those social sections involved, like the books had green stickers on them. There's a photo of those sections in the court documents, which is why when I spoke to the Independence County library director, the fact that she said they're going to put some stickers on some books, it really stuck out at me. Marking those books as separate from the rest of the collection, because Crawford County got in trouble for that. They are a defendant in the Act 372 case, but they also were sued in a separate case by 3 parents of kids who used the Crawford County Library. They said this was a First Amendment violation, and they won that case in 2024. So a judge ordered the Crawford County Library to put those books back in their original sections, and they did. The county was included in the Act 372 case because when the law went into effect, local officials said that law was a good reason to keep the social sections. So that's how Crawford County is mixed up in all this.
Whether they wanted to be or not. All right. I know on Friday there is a state library board meeting. What is going to be discussed then?
So the state library board meets 4 times a year, every 3 months. One of their standard operating procedures is to approve distribution of state funds for public libraries. They do that every time almost without a hitch. They are expected to discuss proposed rules for funding libraries that have been in the works for several months now. Those rules wouldn't go into effect without the board's approval and then further legislative approval. The rules themselves have caught a lot of attention because they are somewhat similar to Act 372. They would require libraries to ensure that patrons who are 16 or younger can't check out certain materials that depict or describe sexual contact and behavior. There's an exception in there for sex education that's kind of limited, but if libraries didn't put those practices into place, they wouldn't get state funding. What is unclear is whether the board will still believe these rules are necessary now that Act 372 is expected to go into effect. So the rules are on the agenda for Friday's meeting. They're expected to be discussed. What we don't know is whether they will vote to send them to the legislature for approval. If they do, it stands to be expected the legislature would approve them since they did pass Act 372.
I was going to say, what happens. It's very similar to what Act 372 is. All right, Tess, thank you so much again for all your reporting on this. It's good to talk with you again.
Thank you. Appreciate it.